All right, good afternoon, everyone. Today is Wednesday, February 15th, 2023. We have 11 bills on the docket, and we'll start off with Senator Guile with Senate Bill 450. We'll then move to Senator Kramer, 249, Senator McKay, 383, 373, 374, 252, 303, 427, 254, and then we'll end up with Senator West with Senate Bill 446. So without further delay, Senator Guile, you are up. Welcome.
Very first bill hearing, so I very much appreciate it. And I have a panel as well, but I think some of them may still be coming in, but thank you. So good afternoon. For the record, Senator Dawn Guile from District 33 here to present SB 450. To illustrate the problem that this bill addresses, I think it's most helpful to tell a story of the problem. And I'm using an example from one of the letters of support. A woman with an intellectual disability was in an abusive relationship. She was violently beaten by her abuser in her home. Police were summoned, and the abuser ultimately was arrested and jailed. After this incident, her landlord sent her a notice to vacate, i.e., she was getting evicted. I think we can all agree we want safe communities, and we also want to ensure that people don't risk losing their homes for calling 911. Indeed, as a matter of good policy, we want people to contact emergency services when the need arises. The problem is that well-meaning nuisance laws in certain counties and municipalities have led to the problem I just described. These nuisance laws were set up as a mechanism to fine property owners of buildings with repeat criminal activity, which may be determined based on the quantity of police reports, arrests, convictions, or even in some jurisdictions, calls for services. Some local governments will fine a property owner for as little as 2 calls for a police service to the property within 30 days. And if there are repeated infractions, the property owner can lose their rental license and/or use of the property for up to a year. Consequently, the landlord, rather than risk losing a rental license or facing fines, will just evict the tenant before he even gets that far, even if the tenant did nothing wrong. There are, of course, many valid reasons why someone would call 911. If a person has a chronic medical condition, including a disability, and needs emergency medical services, to call police, to report suspicious activity, to report a fire or other such emergency, or even Good Samaritans calling to report a crime and more. We certainly do not want to deter a person from making that call because they fear losing their home. I hope you will also consider that the most vulnerable Marylanders are the most impacted by this fear, including those with disabilities, victims of domestic violence or trafficking, and those of lower socioeconomic status. This bill would ensure that every Marylander can summon the police, the fire department, or emergency medical services when they need it and not fear retaliation by their landlord or their local government. It would prohibit the eviction of tenants for utilizing emergency services and prohibit local jurisdictions from passing ordinances or laws that penalize owners for calls for service. Certainly convictions, police reports, things like that, other measures of real criminal activity would be allowed. It also prevents leases from having language, including calls for emergency services, as grounds for eviction. This bill passed the full House last session. 11 other states have passed a similar law. I would also note that there are numerous letters of support, none in opposition, from a range, and the letters of support cover a range of groups, advocacy groups, as well as property owners, including the Maryland Multi-Housing Association, and MACO also filed a letter of support. I would therefore ask for a favorable report on SB 450.
Excellent. Thank you very much, Senator. We have a couple of questions from the committee. This being your first hearing, everyone's got a question for you. I'm kidding. All right. We actually do have a couple of questions in earnest.
Sure.
We've got Senator West has got a real question.
Thank you, Mr. Chairman. Actually, I do have a real question, but it's typical to haze new members of the General Assembly. Blitzing them with questions that when they have their first hearing. So if you hadn't told us that, we wouldn't have known. So is this a problem? I just can't imagine a landlord trying to evict a tenant because the tenant needed to call an ambulance for some reason.
What are
What
the
is
repeated
this?
services? Or
Under what circumstances does this happen? That a landlord thinks it's such a problem, the landlord tries to get rid of the tenant.
It is a problem, and you will note there's a letter of support from the legal aid where they've indicated that they've represented tenants in these very situations. It's a fear of the landlord losing their rental license or being fined.
Because a
So,
landlord, because the tenant has a heart attack?
well, it's like the tenant, I think they're right. So if the tenant is calling 911 for service, or they're calling emergency services, you know, I would hope that in a situation of a heart attack that, you know, a landlord wouldn't evict. But I think, let's say for the example that I gave at the beginning of a victim of domestic violence, if the landlord just wants to evict the problem tenants as opposed to in keeping them there or risk fine or losing their rental license,
Wow.
it may do just that.
Well, there's no question. If this is happening, you've got my support because it's
Thank you.
outrageous that a landlord would try to evict a tenant who's had a heart attack because because the tenant is called an ambulance.
Thank you.
Thanks.
Thank you, Mr. Chair. So thank you for bringing this bill. Senator West, this also will prohibit municipalities for doing that. I know that I've actually had a couple different municipalities come to me asking me to pass laws that will apply some form of a mechanism to the landlord because they've had a tenant who has used these services, and what they see it as is too many. So it's a real issue. So thank you for bringing this
Thank you.
bill. Isn't that so?
Thank you.
Thanks for bringing the bill. Thank you, Mr. Chairman. So under the ADA with the NRA and the EEE. No, I'm just kidding. Listen, so I just want to clarify, this bill is more for nuisance responses where the police are responding, as I understand it, because when you have domestics, and the situation you gave would be that the landlords are worried about, especially in municipalities where they have their own police force, that there's a continual presence and summoning of law enforcement there, law enforcement services. And then they risk the gamut by doing their due diligence and trying to have the law enforcement intervene. And the landlords just don't want a lot of police cars there. So I don't know of any other situations, like Senator West said, with actual summoning of emergency vehicle or EMS, but I would think that this is predominantly the situation that you're trying to avoid, the one that you spoke about originally. Is that correct?
Yes, that's correct. So the nuisance laws that are well-intentioned to decrease high incidence of criminal activity in certain multi-housing buildings usually. That was this effort, and it's a way that they characterize that level of criminal activity is it, you know, police reports, convictions, or calls for service. So not all of the jurisdictions include calls for service in that determination, but there certainly are that do. And I think even those that don't even include calls for service are still this like concern by the tenant.
Yeah.
Hey, if I call, you know, then I can risk getting kicked out.
Yeah, we don't want people to be fearful of that. So I
Yeah.
fully appreciate and support the bill. I just want to make sure that we all had a clear understanding that this was because sometimes tenants or landlords just don't want too much presence of law enforcement there because it makes people think poorly upon the area. So thank you.
Yeah. Thank you, Senator.
Thank you very much. Does the legislation as intended have any effect on commercial leases?
No, it would just be residential. I don't think that there would be any contemplation that this would be eviction of, let's say, a store or something like that. I would have to double check, but I think this is only applicable to residential leases.
And the only reason I ask is sometimes you have problems, commercial businesses and things in districts, and one might want them to be evicted and put out. So while I understand residential, I just want to be clear that it's not commercial that we're talking about.
Right. Oh, thank you. A member of my panel just pointed out to me that it's only applicable to residential.
Thank you.
If I may, it looks like, section, it's 14-126. It's under, rental license, number 5. It says rental license means any certificate, license, or permit required to residential real property issued by a county or municipality. Thank you.
You're on page 4, line 16 through
4.
18,
Yep, 4, page 4.
the definition of rental license. Okay, thank you.
Thank you.
Additional questions from the committee? Seeing none, thank you very much, Senator.
Thank you.
Thank you. All right.
Thank you. Good afternoon, Mr. Chairman, members of the committee. Feels like I was just here. I am Melanie Shapiro. Here in support of Senate Bill 450 on behalf of the Maryland Network Against Domestic Violence. We represent the 19 comprehensive domestic violence programs as well as other allied organizations and individuals. I'd like to thank Senator Guile for bringing this important bill. And I think just to reiterate what Senator Folden has already indicated, this will actually have these nuisance laws have a very detrimental impact on victims of domestic violence. And whether it's because they individually seek to call for emergency services, or sometimes there's even a neighbor who hears something and calls emergency services. And housing instability is a real issue for victims of domestic violence, with 38% of all victims experiencing homelessness at some point in their lives. And so ensuring that laws such as this that prevent housing instability for victims of domestic violence and tell them that if they wish to call or need to call law enforcement or emergency services, that they will not be penalized for doing so. It is just another path to safety for victims. And that's why we are urging a favorable report on Senate Bill 450.
Good afternoon, Mr. Chair, members of the committee. I'm so sorry to those of you who had to close out your Valentine's Day with me last night at around 10:30 at night. I direct the Human Trafficking Prevention Project, an organization that's focused on providing legal services to criminalized sex workers and survivors of human trafficking, as well as promoting systemic change designed to prevent exploitation from occurring. To Senator West's point previously about these types of calls in terms of ambulance calls, some local ordinances defined excessive calls for police or emergency services, just 2, as being excessive, even when the tenant is specifically contacting these services because they've been the victim of a crime. Obviously, this deters overall reporting, to Senator Folden's point, but this also can result in deterring landlords from even renting to crime victims. Like if they can see that they know that there was a protective order put out, or if that person sought a protective order, they can actually use that as a way to not rent to them. Additionally, these nuisance ordinances are routinely used to target Black and Brown communities for eviction and displacement, who are already put at disproportionately high risk of exploitation and interpersonal violence. And specific to trafficking survivors, which is obviously our focus, in addition to deterring victims of crime from calling law enforcement, et cetera, both housing instability and homelessness factor heavily into recruitment and control processes for traffickers, who commonly offer, quote, safe shelter as a coercive means of recruitment, only to use victims' fear of being turned back out onto the street as a means of control. In addition, traffickers can use the existence of these types of laws to further their control by reminding them that if they do intend to try to report what's happening to law enforcement, they will be fined or evicted. And so in addition to all the points that I'm sure the panelists will soon make, the HTPP supports SB 450, urges a favorable report, and thanks Senator Guile for her sponsorship of this bill. Thank you.
Thank you, Chair Smith and members of the Judicial Proceedings Committee. My name is Samuela Ansa, and I'm the voting rights advocate at Disability Rights Maryland, where we work to protect and advance the rights of all Marylanders with disabilities. And I'm pleased to be here in support of Senate Bill 450. As the previous panelists have highlighted, the current law has serious implications for all Marylanders, especially survivors of domestic violence and people with disabilities. In our written testimony, you'll find a number of client stories that highlight just how pervasive the current the current law is. For example, please consider buildings with older elevators that break down frequently, and people with physical disabilities often have to call for emergency services to be able to exit and enter their units. And you can imagine how a landlord will use that will cite that as a nuisance and a reason to evict or serve a notice to vacate. Evictions put people with disabilities who need vouchers and assistance to afford their homes and to live independently at risk, and jeopardize their access to the already few and limited physically accessible units that are out there. This also puts people with families with loved ones with behavioral health disabilities and experiencing a mental health crisis at risk between choosing emergency services for their loved ones or stable and safe housing. And no one should ever have to choose between summoning life-saving emergency services or their housing. So for those reasons, Disability Rights Maryland and all the organizations and individuals you see sign on to our written testimony urge a favorable report on Senate Bill 450. Thank you.
Good afternoon, Mr. Chair, members of the committee. My name is Gregory Callis. I'm with Maryland Legal Aid. And we would urge a favorable report on Senate Bill 450. We think this bill is perfectly crafted to address all aspects of this particular problem. It prohibits lease terms, excuse me, I'm sorry, that would allow landlords to use this sort of conduct to evict and make homeless individuals. It provides for a cause of action for retaliatory eviction if a landlord decides to do that sort of thing. And it addresses a problem that we think it sort of underlies a lot of the conduct, even the conduct of the landlord in putting in a lease provision or, evicting or attempting to evict someone who is called emergency services in order to protect their lives. And it's because these nuisance provisions and to address Senator West, whether or not a landlord would do this, the landlord's incentive or is incentivized to do this by nuisance provisions that are throughout the state. And even though those nuisance provisions in each one of the jurisdictions are somewhat different, what they do allow is a community association or it may be the county attorney or whomever to start an action to actually fine or take the property away from the landlord if they allow these sort of nuisances to exist. And nuisances are in some cases so loosely defined as to include this sort of conduct. And so this bill gets to the heart of the matter. And we again would urge the favorable report. Thank you very much.
Excellent. Thank you very much. I just had one question about, have you run this by like the Maryland Multi-Housing Association? It's really with respect to the damages piece. It's pretty standard language, but
Yeah, if I may, Mr. Chair, the Maryland Multi-Housing Association filed a letter of support.
excellent.
Favorable.
I see the nodding in the back.
Right.
All right. Seeing no further questions from the committee, thank you very much, Senator, and thank you to the panelists. Thank you all. Good to see you all again. 10:30 last night and 1 o'clock today. Yeah. All right. So with that, that'll conclude the hearing for Senate Bill 450. We'll now move on to Senator Kramer with Senate Bill 249. Senator Kramer, welcome. Would you like to bring up your panel? I think you got two people.
I have this extensive panel with me, Mr. Chair. Unlike up in Finance Committee right now, where Senator Lamb has brought a cast of thousands for a bill hearing, all of whom are signed up favorably.
That surprises me not.
So I'm good being here visiting with you, Mr. Chair. Ready to go? All right, good afternoon, Mr. Chair, colleagues. Ben Kramer introducing Senate Bill 249. Colleagues, this one is easy. With passage of recreational cannabis, we know for a fact that crashes on our roads are going to increase dramatically. Deaths and injuries from impaired driving are going to go up dramatically. And this bill is just a tiny step to try to have looking forward as to how we can maybe start to focus a little bit on the public health, public safety, and public welfare side of recreational cannabis. So the bill before you simply reads as follows. The curriculum required by subsection B, and that is driver's education, shall include information on the laws relating to, and very importantly, the risks of driving while under the influence of cannabis. There is an amendment that will be in the committee's hands before the end of the day that will add "and alcohol," which came out of a conversation I had with our friends at the Motor Vehicle Administration a couple of days ago. They said, how about an amendment just to also put in there alcohol? I said, I think I can make that happen. So it'll be forthcoming. But I think it's critically important that this first generation of new drivers coming out at the inception of legalized recreational cannabis use start to get significant cautionary tales and education. There is no question that cannabis can impair an individual's ability to properly drive a motor vehicle. So that's it, folks. I mean, you may want to vote this one up before I finish leaving the room, and I think Senator West is all on board. So with that, thank you, Madam Chair, and I'm glad to see that the Maryland Cannabis Commission has submitted written testimony in full support, along with our friends at AAA. But Mr. Kurt Erickson here has been with the Washington Regional Alcohol Program for years. He and I partnered on Noah's Law and getting that passed, and it took a number of years to do it, and he was a close partner on getting that done, and I'm glad to see that he was able to make it to Annapolis this afternoon to show support for this legislation as well. Thank you, Madam Chair. Oh, for me? Yes, sir.
It's a very good bill because it's scary, and when I see not just the increase in accidents, but the kinds of accidents, it's as though people have just lost all sense of anything that's civil. I know that for alcohol, you can detect, if I'm at a 0.08. What scares me about this is there a test so that if a police stops someone, an officer stops someone, and they're not drinking, but it's obviously hi, something's wrong, but how do you prove that? What do you do? That's a scary thing. And does this bill address that at all? Or what kind of curriculum will they put together? Even if they put curriculum together, there's pretty much nothing you can do to enforce it if people decide not to. But just as we do with drunk drivers, how do you get them off the road? How do you get those who are abusing cannabis off the road? Is that a part of this conversation?
So I mean, these are two very separate issues. The goal here, of course, is education and start teaching out of the gate here are the problems
And
that
that's what
are
we do.
associated. But you are absolutely right. To date, there is no technology that can do the same thing that you can do with alcohol and testing for intoxication. There are a number of manufacturers, and I actually had one contact me last week indicating that they've got some great technology that they were representing
Okay,
could be a possible alternative.
with young people, we've got to do something. And I'm wondering what kind of curriculum, if it's, and I'm supporting it, but it's also concerns me that to just give them something and say, don't do this, don't do that, and they're gonna go out and do it anyway. But how do I protect my citizens from them, just as I fight about drunk
That's going to
driving?
be a huge
What's the
problem.
next step after
Yep.
this?
No, and that's why, as part of the cannabis legislation that will be coming out, I have been emphasizing the importance of putting money into police training. That's a key aspect because our police officers are going to have to be really well-trained and in tune to detect
Right, correct.
a driver under the influence of cannabis. And I don't take issue with you, and I have been very focused on, and I've said this repeatedly over the last couple of years, health, welfare, and safety of our public. And this is just a small piece. That's why I was saying this should be an easy step. We do need to focus on the concerns, the legitimate concerns that you've raised about additional steps to protect all of our residents, whether they're behind the wheel of a car or a pedestrian, because we have seen dramatic increases in other states of
Yes.
auto accidents involving.
Overnight, it's something
Yeah.
to this, yeah.
Nope.
Thank you.
Very well taken. And you and I share that same
I'm
concern.
looking to work with you on it. Thank you. I think that Chair said move favorable, and I heard a second before he comes back.
Not
in.
quite yet, but we're getting there. Senator James.
Thank you.
I like your way of thinking.
Hey, Senator Kramer, I
Hi there.
actually coincidentally have a report on the changes in traffic crash rates after the legalization of cannabis. I could share with anybody. But I don't know if you happen to see it, but MDOT wrote a letter and said the MVA, and it made sense to me, and I'm sure they do it, already teach this. In fact, what they say is in Unit 9, of course, they go over alcohol too, and cannabis, and I'm sure any drugs that people might consume while driving, the legal consequences of operating a motor vehicle under the influence of drugs and alcohol, including cannabis, which would be exactly what you're saying, information on the laws relating to driving while under the influence of cannabis. And then they go on to also talk about the effects of cannabis on the body's effects on cannabis on the body and how it impacts driving ability. And I guess that would be what you were saying about the risk of driving under the influence of cannabis. So I don't know if you saw this, but I think they're already doing it.
We had a conversation last week. That's what I was referencing. The MVA called me to discuss it last week and acknowledged that with my point being, with the new recreational cannabis, we need to double down on there is very generic education on drug use in general. I think typically speaking, there's been a heavier focus on alcohol. But my point with the legislation in my conversation, there was an acknowledgement that, yeah, we know that when things are put into law, that we tend to look a little more seriously at what it means, and that it doesn't change from administration to administration, that we put in law those things that are going to be required, not simply adopted at any point in time.
So I will be just a little bit rhetorical with you. So
Sure.
have we legislated the alcohol risk education of the MV, which is actually a huge problem that's been going on for decades.
Yes.
And for now anyway, has been historically a much larger and deadlier problem.
Yes.
So did we legislate the education that?
So
because maybe-
in my introduction to my comments, I indicated that after my conversation with them, the suggestion was, and by the way, how about an amendment add alcohol? So that's the amendment I said will be before the committee before the end of the day. Out of that conversation, I immediately had an amendment prepared that will simply say and alcohol. And that came out of that conversation.
I'm sorry if I missed that. You're
No,
saying,
perfect.
Thank you, Madam Chair.
Absolutely. Thank you.
Thank you, Senator. So there appears to be no unfavorable testimony, and the state's attorney, Baltimore County State's Attorney, offered an unfavorable with no testimony. I'm curious to know what could possibly be the opposition to education for driver education for alcohol and cannabis. Do you have any idea?
I do not, and I had not seen that. I thought I had copies of all the.
It's not written, it just says unfavorable, no testimony. So I was just curious, what could be the reason, if you knew?
I hoping that was a mistake.
Okay.
I'm hoping that was done in error.
Thank you very much. Your next witness, if no other questions?
Madam Chair, my name is Kurt Erickson. I'm president of the Maryland nonprofit Washington Regional Alcohol Program. This bill is going smoothly, so let me not interrupt that flow. With the exception of saying that you have our written testimony. So let me just mention underscore 4 points in that. As the senator mentioned, that all this bill does is to simply have the state's driver education curriculum include information on the risk of driving while under the influence of cannabis. 2 is to underscore the U.S. Centers for Disease Control findings that found driving under the influence of drugs, including marijuana, is dangerous and illegal, and marijuana can impair important skills required for safe driving by slowing your reaction time and ability to make decisions, impaired coordination, and distorting perception. 3, and this was hinted on, and I appreciate bringing up the recent Insurance Institute for Highway Safety study, is that with Maryland poised to legalize recreational marijuana, there was a 2021 study by the Insurance Institute for Highway Safety concluded that crash rates jump when states legalize recreational use and sales of marijuana. And therefore, what this bill does is to install guardrails in the form of requiring MVA to include in the state's driver's educational curriculum what the senator had mentioned in terms of the risk of cannabis. 4th and lastly, you combine everything that you've heard with the facts that with the number of licensed drivers in the U.S., licensed young drivers, 15 to 20 years old, actually going down, which is, I think, surprising to some. It's gone down by 4.7% in 2020, yet the numbers of fatalities, including these same drivers, increasing, and not just slightly increasing, but increasing by a double-digit percentage, 17%. You've really underscored both the need to fortify the state's impaired driving prevention education efforts and for this very legislation. And to that end, we beg your indulgence to consider favorably reporting it. Thank you.
All right, thank you very much. Seeing no further questions from the committee. Thank you, Senator Kramer.
Thank you, Mr.
Thank
Chair.
you.
Thank you, committee.
All right, thanks. All right, with that, that'll conclude the hearing for Senate Bill 240. I'm sorry, my apologies. Oh, Rusty Carr, did you want to testify? Anyway, are there any other folks that want to testify? All right, going once, going twice. Are we coming up?
Thank you, Chair Smith. Thank you, committee members. I'm here. For the record, my name is Rusty Carr. I'm a resident of Mount Airy in District 4, and I'm here to testify in favor of 249 with amendment. My amendment is concerning the education of impairment and the determination of impairment when using cannabis. The issue of, for example, my mother is a 91-year-old lady who is consuming cannabis via tinctures to treat scoliosis pain. She used to be on a fentanyl patch. She's now consuming non-impairing doses of cannabis. She's still driving. Is she under the influence of cannabis or not? It's a non-impairing dose. Most of the legislation that I've seen concerning cannabis says under the influence. of cannabis. We have laws that say you can't drive while under impairment. And I request that you folks can consider that it's possible to consume cannabis and not be impaired and to be able to drive. I consumed cannabis this morning. I drove down here. It took an hour to drive down here. But I waited 4 hours to make sure that I was not impaired before I left. I know that if I consume cannabis and go out driving, that there is a drug recognition expert protocol for determining if I'm driving impaired or not, whether I'm consuming cannabis or any other drug, alcohol or prescription drugs. For that reason, I ask that you include the education about impairment in the bill. Thank you very much. No questions? Thank you, gentlemen.
All right, thank you very much, Mr. Carr. And with that, seeing no further questions, that'll conclude the hearing for Senate Bill 249. There's a joke in there somewhere. I don't know. It took you 4 hours to drive somewhere after consuming cannabis. That's funny. All right. With that, we'll move on to the next bill. Senator McKay, are you ready to go with Senate Bill 383? Thank you.
Mr. Chair, Mr. Vice Chair, members of the JPR Committee. For the record, I am Senator Mike McKay, presenting Senate Bill 383, Notice of Intent to Travel, or better known as the Maryland Child Abduction Prevention Act. There's nothing more important than the well-being of safety of our children. They're the most vulnerable in our society, and they deserve nothing more than security and their innocence to be protected. Bill 383's main goals are: number one, during a custody proceedings, either parent must provide advance written notice to the court and any parent of intent to travel outside the United States with the child. Number two, the court can order abduction prevention measures in a child custody proceedings if they've determined that there's a credible risk of the evidence provided. Number three, a parent can thus file measures themselves, feel that the evidence establishes this as well. And number 2, 3, 4, this applies retroactively and will affect any parent desiring to travel internationally with a child or children that they share a parent, share with another parent. There is an amendment that we have drafted. It has been requested. It puts it in the same posture. This bill is cross-filed in the House with Delegate Bartlett. And this bill has come to this committee a couple times. And so some of you are familiar with it, but I thank you for your time and ask for a favorable vote. Please. Ladies first. I'll pick.
Hi. My name is Nicole Priola, and I'm here to testify in favor of SB 383, the Maryland Child Abduction Prevention Act. I would like to explain a small portion of what my brother has had to go through trying to have his son returned from being internationally abducted. My nephew, August Priola, was abducted from Hawaii to Greece on September 5th, 2017 by his biological mother, Mado Nicolai Hedo. Sorry, can't say her name. His now ex-wife, a Greek citizen, used the U.S. courts making false allegations against my brother, filing a temporary protective order to have him removed from the home so she could leave the country with their then 2-year-old son. Anthony informed the local police and the courts she was planning to abduct his son and requested that his son's passport be turned over to the courts, but they refused. The protective order was dismissed. He, along with my mother and brother, went back to his home, found it ransacked, his wife and son missing. He found that she had left Hawaii and was at LAX. The Hawaii Police Department in Hilo refused his request to enter his child into the National Crime Information Center missing persons file. Due to this negligence by law enforcement, she was able to leave the country with their son. Anthony has full physical and legal custody of his son, who is now 7. There are U.S. return orders and warrants for her arrest, and we still receive no help. Although Greece is a signatory of the Hague Convention of International Parental Abduction, we have not found one documented case where Greece has returned a child. Greece, like many other cases who violate the Hague Treaty, are still on the compliance list with the U.S. Department of State. Anthony has been in Greece several times since the abduction of his son. He has limited virtual communication. In one Skype call, Anthony noticed marks on his son's neck, bruises on his collarbone. When asked August about the markings, he tried to cover them up and then said the man upstairs did it. Immediately, his mother turned off the computer. Anthony was able to snap a photo before she turned off the computer and reported the abuse to the FBI U.S. Embassy in Greece and the U.S. State Department. His attorney's child services in Greece, nothing was done. During his last visit, he saw bruises once again. We, like so many other left behind parents and families, have to go through so many obstacles to get help to return our children. I had no idea how common parental abduction was until this happened to our family. We had to educate ourselves and realize most information given to parents and by law enforcement regarding parental abduction is incorrect. Currently, over 100 children have been parentally abducted from the U.S., taken to another country. And as you heard here today, the struggles we face to return them. It all starts with prevention. Passing this bill and providing education on parental abduction to judges, lawyers, and law enforcement will not help bring my nephew home, but it's a step in preventing future abductions. Thank you.
Good afternoon. Thank you for the opportunity to speak today. My name is Davin Sloan, and I'm here in support of Senate Bill 383, the Maryland Child Abduction Prevention Act. I seek your help to create meaningful protections for our children, young Marylanders who are at risk of international parental child abduction, and to bring awareness to the devastating consequences of international parental child abduction. I'm the proud father of a delightful daughter, now nearly 9 years old, and she is my only child. She was born here in Anne Arundel Medical Center. Now she's a U.S. citizen, a Marylander, and an Annapolitan. My daughter was and is a survivor of international parental child abduction. In 2016, while married, I traveled with my daughter and foreign-born wife for what I thought was to be a long summer vacation in the Czech Republic. I discovered to my horror and anguish that my child's mother had a different plan and, unbeknownst to me, had no intention of returning home to the United States with her child. From September 2016, my daughter was unlawfully and wrongfully retained in the Czech Republic for nearly 3 years. Excuse me. 1,012 agonizing days. For the excuse me. For the first 2 years, my contact with my daughter was limited to a total of 16 hours. In 2017, I initiated a Hague proceeding seeking my daughter's return home. Pursuing my daughter's return required 5 separate trips to the Czech Republic and a total of 189 days overseas. Few parents could manage this, much less the tremendous costs. I've now spent over $250,000 fighting for my daughter's return and well-being. Sadly, most of the court costs have been incurred in Maryland family courts. Despite the Czech appeal court and constitutional court rulings requiring my daughter's return to the U.S. under the Hague Treaty, the taking parent would not comply. In July 2019, the Czech court moved forward with enforcement actions. Police, social workers, court officials arrived at the house where my daughter was and had to physically remove her. This is an extremely traumatic experience for my daughter. I'm one of the lucky ones. So on July 4th, 2019, I was finally able to return with my daughter to our home in Annapolis, Maryland, almost 3 years after our planned return. However, upon my return to the U.S. with my daughter, I encountered grave and unexpected obstacles. There is currently no framework in Maryland to prevent reabduction or to accept or grant comity to Hague return judgments. Foremost, our family courts must be made aware of the loss of jurisdiction that occurs the moment the airplane wheels leave the runway. From then on, enforcement of U.S. custody orders is not possible. This is paramount in understanding the need for protections for our children. Family courts should be required to enroll at-risk children into the federal CBP Prevent Abduction program, which would help to prevent unauthorized departures. There is an urgent need for uniform and automatic procedures to protect children from abduction and reabduction when there are known incredible risks. Secondly, requiring and facilitating mirror agreements with foreign courts and authorities would help ensure U.S. Custody or travel agreement enforcement. My daughter remains at risk. Among the well-established risk factors are parents who have previously abducted that present the single greatest risk of reabduction. The risk factors are shared by the State Department, the U.S. Justice Department, National Center for Missing and Exploited Children, and others, and they should be used by our family courts to assess this risk. U.S. Congress and most experts recognize parental child abduction as a form of child abuse, but incredibly, Anne Arundel County abduction is not recognized as a form of child abuse. This must be changed. Abducted children suffer a multitude of short and long-term psychological damage, not to mention damage to their future, with parents having to spend a lifetime of their savings on legal fees rather than college tuition. Clearly, it is a worthy goal to focus on preventing abduction from occurring in the first place. I ask for your help to pass this legislation so that my daughter and others like her can be better protected under the laws of this state where she was born. Thank you.
Thank you very much for your testimony. And we have just a couple questions. Senator Muse.
Yes, thank you very much. I went to the gentleman who just spoke. I just have a question direct to him. I can't see him. There you are. There you are. I get involved in this a lot in my other life with families, counseling, breaking up, et cetera, et cetera.
Yes.
And this has been a problem that has come to me so many times in many ways. So I just want to ask you, what's been your experience in the court? You said you spent $250,000.
Yes, sir.
What were the options that you were given, or what did lawyers say that you could or couldn't do that has not resulted in your being able to have that shared custody?
Yes, thank you for your question. To begin with, I filed a Hague complaint starting in the foreign country, and I'm very glad I did it that way. And my expenses for achieving my daughter's return and over the course of 3 years and going through many, many court hearings, including the Czech Republic's highest court, the Constitutional Court, and fortunately resulting in a successful return of my daughter. Those expenses were only about $50,000. When I came back to the United States, that's when I got to spend the rest of my retirement account on the Maryland family courts. And my case was treated mostly as an adversarial divorce. And although all the findings of the Hague process were completely documented in very long and well-translated documents, and they're submitted to the courts, they just go in a file cabinet. And really the fact that this had happened was not became not a predominant consideration. In the end, I ended up having to settle because going to trial was so expensive. And so I've got shared custody with the mother who since returned to the United States, but I have some decision making on medical and some other aspects. But that's how it has ended up. But my daughter is still at risk until she's grown. And that's the important thing that the courts fail to understand, and everybody fails to understand. They think as time goes by that the risk is ameliorated, and it simply isn't. The risk exists. It's most profoundly for people who have done it before, people who don't have property here, people who don't have family here, who do have property, do have family in the other country, and all these boxes are checked off. And I'm terrified that this can repeat itself. And if it does, I will actually be in a worse position because they don't start from where they left off with a, hey, you start a new case with all new things, and they would accept the testimony of my daughter. And if she's coerced into saying under duress that she wants to stay there, they may actually accept that statement and not allow her return in the first place. And not to mention the fact that I couldn't afford to do this again.
You use the word adversarial. Did you, relative to the courts, why did you think? Is it because you're the father? You said somewhat dismissive, adversarial.
When I came back, and a variety of things happened. It's very complex, but during Pendente Lite hearing, for example, the judge, when we asked for my daughter to be placed on the no-fly list and to be given protections against reabduction, which was an extremely grave concern then. She said, I don't know about this and it's not my job. And I said, I thought you should know about this, and it certainly is your job to understand this. But I have come to find out that that the family law judges simply aren't aware of the and they have this predominating idea that if they write a judgment that it's enforceable, and they just don't understand. It just evaporates as soon as the child leaves the country, and even countries that are signatories to the Hague, many of them do not return children successfully, and it's a tremendously expensive and arduous process. It took me 3 years to get my daughter back.
Thank you, and thank you, Mr. Chairman.
Thanks, sir.
Thank you. Senator, as I was looking at, I think it was maybe the sole piece of opposition in the bill filed from Maryland Judiciary. And it says, unfortunately, the bill's language casts a much wider net. Well, let me start. It says the title of the bill suggests its intention to prevent child abduction, which is an important and laudable goal. Unfortunately, the bill's language casts a much wider net and likely will have some significant unintended consequences. And it kind of goes on. I'm curious, have you had an opportunity to speak with them about their concerns and any ideas about how to address them?
So I have not been able to do that. Some of the concerns from some others are with the amendments. The amendments that I have do not through the judiciary. But if you look back through the history of the bill, they've been consistent in their opposition of this.
Yeah.
So I'm not sure that we're
going to see eye to eye on it.
Yeah, I just don't.
Understood.
Thank you. It's those things you lawyers like to discuss. Us lay people just want it fixed. Isn't that so?
Thank you, Chairman. Senator McKay? My question is similar to Senator Sidnor. I was looking at the Women's Law Center's favorable with amendments suggestion, and they suggest that the current language does not achieve its intended purpose, and they suggest an amendment that would simply enact the existing Uniform Law Commission's Uniform Child Abduction Prevention Act. Are you familiar with that? And is that in fact a solution to your knowledge?
So to my knowledge, no. But I am not, this bill in the House was already heard. And so some of the amendments that we have put in were from that hearing as well. So I would have to follow up and give the committee a report back.
Thank you.
that
And we don't have the amendments yet, do we?
No, we don't.
Okay, thank you.
Thank you.
All right, Senator McKay, thank you very much. Seeing no further questions from the committee, thank you to the guests as well. Thank you all for taking the time to share your perspective. We'll now move on to our virtual participants, and we'll start off with Mr. Syed.
They're gonna call. Yeah.
Thank you, Mr. Chairman. I want to thank the Judiciary Committee and Senator McKay for this opportunity. My name is Arif Syed. I'm a father of Hadia Syed, and I stand here before you as a stay-at-home dad whose child has been abducted almost 3 years now, when she was taken out of state without my knowledge or court's consent, and she remains at risk of being abducted internationally. I have been struggling ever since, and I continue to feel lost and helpless, facing the prolonged inaction by the family court system, with 3 postponements so far and no resolution in sight. I do not feel, I believe that the current system has failed me and is failing families like me. And I would appeal to this House and the Senate to understand that there can be nothing more traumatizing and devastating for a parent than to be separated from their child, other than how it puts and places the child's safety at risk their mental, emotional, and psychological well-being. I understand that the lack of tools and there is a lack of clear legislations combined with the delayed response from authorities, which has led to an increase in these incidents, destroying families, which are the structural unit of our society, and also affecting children who are our future. That's why I would urge all the members, respectable members, to please support this bill. It's been lingering for 2 years, and I have been working with others on this bill for past 2 years, and I still have no resolution. We have limited resources. Our life has turned upside down. Our family's life has turned upside down. I would urge that this will be passed. And I thank you for your time and consideration.
Excellent. Thank you very much, Mr. Syed. We'll now turn to Mr. Labrie. Welcome.
Thank you very much, Mr. Chairman. I'm Laurel Labrie, and I speak in favor of SB 383 with a modification of page 7 from Department of State to Department of Justice, Office of Justice Programs. Although I have lived in New Hampshire for a year now, my custody case remains in Baltimore County Circuit Court. There's an international abduction from Maryland every 2 weeks. The District of Columbia and 14 states, including Pennsylvania, have kept passed forms of the Uniform Child Abduction Prevention Act, UCAPA. The time has come for Maryland to protect its children too. SB 383 was based on the UCAPA of 2006. Then we consulted with the National Center of Missing and Exploited Children and 3 abduction recovery nonprofits that have testified over a dozen times to U.S. congressional subcommittees. We added what they have learned in the 17 years since UCAPA was passed. So parents with dozens of years of combined experience have put dozens of hours to work into bringing this bill up to date. Then we worked with Senator Reedy and Delegate Cardin to apply it to domestic cases as well, and to divide our 21-page bill into SB 383 and 2 amendments, which we hope to propose in future years. Thank you to Senator McKay for reintroducing it. The other amendment submitted by Senator Reedy in 2020 on our behalf was that the courts recognize the anxiety, conflict, and harm that comes to families where many warning signs of abduction exist. In my case, changing the mind of the judge to order travel precautions required appointing a best interest attorney to allow my twin girls to voice their concern. The court twice rejected motions for a BIA until one of their therapists assisted in getting him approved. The court finally heard my children's anxiety and reversed 2 previous rulings, and it ordered travel precautions that have prevented a second abduction. Yet my girls won't recover from the years of anxiety or the hundreds of thousands of dollars in legal fees diverted from their future. Therefore, I request that this committee give a favorable report to SB 383 with these amendments. Thank you.
Thank you very much, Mr. Labrie. We'll now turn to Ms. Snyder. Ms. Snyder, you're up. Welcome.
Thank you very much. My name is Libby Snyder, and I'm a legislative attorney with the Uniform Law Commission, which is a nonprofit organization formed in 1892 to draft nonpartisan model legislation in the areas of state law for which uniformity among the states is advisable. I'm here to speak in favor of Senate Bill 383 with amendments to bring it closer in line with the Uniform Child Abduction Prevention Act, specifically the provisions in sections 7, 8, and 9 of the Uniform Act. The purpose and guiding mission of the Uniform Child Abduction Prevention Act, or UCAPA, is that preventing abduction is always going to be in the child's best interest. Senate Bill 383, as introduced, focuses on international parental child abductions, but UCAPA would expand that focus to also deal with domestic child abduction perpetrated by parents and other family members. The 3 major changes that adopting these provisions of UCAPA would make to Senate Bill 383, as introduced, is first, UCAPA would provide judges with evidence-based guidance to help them identify children who are at risk for abduction. UCAPA includes a variety of risk factors and types of behavior that research has demonstrated may indicate that a child is at risk of being abducted. The more factors that are present, the higher the probability of abduction. The second major change is that UCAPA would help judges by providing a catalog of possible remedies, and it would give judges the tools to issue prevention measures that are tailored to the actual risk found for the situation in question. And finally, UCAPA also provides for abduction prevention in extreme circumstances. When there's a credible risk of imminent wrongful removal, the court could issue a warrant to take physical custody of the child or direct law enforcement to take any action reasonably necessary to locate and return the child. So if passed, Senate Bill 383 with those changes in UCAPA would help prevent parental child abduction in both domestic and international cases in Maryland instead of merely reacting after an abduction has taken place. So I ask for your support to advance the bill with amendments. Thank you.
Thank you very much, Ms. Snyder. Looking to the committee for questions, we've got one from Senator West.
Thank you, Mr. Chair. This is one of the uniform statutes that prepared by the Uniform Commissioners on State Laws. I've always been a strong supporter of these uniform measures because they're uniform. You have the same thing in all the states that enact them. So I sympathize with your concern about enacting a non-uniform version of this. As I look at it, there are a couple of questions I have. I guess one that stands out is, I think some person raised it. Does the Uniform Child Abduction Prevention Act cover travel domestically as well as internationally, or is it limited to international travel? I can't tell that from this bill.
Yeah, the Uniform Child Abduction Prevention Act, which is not the bill as introduced, would cover both domestic and international travel. It would allow a court to enter abduction prevention measures that include things like travel restrictions, prohibitions on removal of the child from a certain geographical area or the state without the other party's written consent or court approval. It could require deposit of documents with the court, so the child's passport or other important documents, restrictions on getting the child a passport. It could require a parent traveling to register the child custody order in the state that they're going to travel to prior to traveling. The travel restrictions could include things like providing the other parent with a very detailed itinerary with addresses and phone numbers for each place that the child may stay outside of Maryland or outside of that geographical area. It gives judges a lot of discretion to impose any of the remedies listed in the Uniform Child Abduction Prevention Act or other remedies not listed, but it gives them that discretion to make sure that the measures put in place are tailored to the situation at hand so that they can prevent an abduction that is, specific to each child in each situation.
Okay, so what you're saying is what we have here is a portion of the proposed uniform commercial law, but not the whole law.
Correct.
Okay, I think we need to take a look at the whole law and compare it with what we've got. And thank you for calling this to our attention.
Yes, Senator, can I say it? The other parts of the UCAP are in the 14 pages that were clipped out for amendment later. So they have been considered and are a vital part of it. So we welcome bringing all of the bill into, all the UCAP into it with the updates that we've learned since then.
Great. Thank you so much.
Thank you.
All right. Thank you very much, Senator West. Seeing no further questions from the committee, thank you both very much.
Thank you,
everyone. All right. And with that, that'll conclude the hearing and the testimony in the hearing for Senate Bill 383. We'll now move on to Senator Ellis with Senate Bill 373. Senator Ellis, welcome.
Thank you, Chairman Smith, Vice Chair Wall Striker, and members of the Judicial Proceedings Committee. I'm Arthur Ellis, representing District 28, Charles County in Southern Maryland. I'm here to present Senate Bill 373, which is a request from the Charles County Commissioners, the legislative body in Charles County, to write regulations and rules governing off-road motorbikes and all-terrain vehicles. So they sent up this request to us here after having public hearing in the county, and they unanimously support this legislation, which will apply only to Charles County and gives the county commissioners the right to regulate the operation of off-road motorcycles and all-terrain vehicles. The regulations that they are looking at is the registration requirements. They're looking at age restrictions on who can ride these motorbikes and all-terrain vehicles. and also looking at the impoundment of these vehicles when they seize them. And that currently, the sheriff's office might impound one of these vehicles and have to give it right back to the offending party. And the officers within hours deal with the same problems over and over again. So pretty much that's it. Pretty straightforward bill. Request a favorable vote on Senate Bill 373.
So one quick question. The commissioners, they wrote a letter saying that it was favorable with amendment. And they,
Right.
So is there an amendment that'll be forthcoming for the all-terrain?
Yes, so the testimony I presented to you was their amended version, including all terrain, all stuff. So what I will work with, your committee staff to get this amendment properly drafted and presented to you. This came into me yesterday, so Valentine's Day. So I think Ms. Mitchell is here from the county. I'm not sure.
Excellent. Yes, Senator, we will have Ms. Mitchell. You're up.
Thank you. Good afternoon, Chairman Smith, Vice Chairman Waldstreicher, and the members. Danielle Mitchell here, Associate County Attorney for Charles County Government. I'm testifying today on behalf of the Charles County Commissioners in support of SB 373 motorized mini bikes with amendments. As Senator Ellis has already stated, the intention of SB 373 was to enable the county commissioners to pass a local law to establish regulations for off-road motorcycles and all-terrain vehicles. There's been sort of an uptick in the use of these vehicles on public roadways as well as private property without permission. So when they're operated illegally, this really presents a serious safety issue, public safety issue in our county. Right now, the bill as written addresses mini bikes, but not the all-terrain vehicles. The code defines mini bikes as having 2 and 3 wheels. We would like to also include the all-terrain vehicles to encompass those 4-wheel vehicles. So with that amendment, the commissioners fully support SB 373 and would urge a favorable vote. Thank you.
So thank you very much, Ms. Mitchell, for the context. Also, when you get the amendments, if you could have a senator, if you could get a delegation letter for us, that would be extremely helpful. Then we can move on it.
Mr. Chairman.
All right, turning to the committee for questions. Seeing no further questions, thank you very much, Senator. You're back up in a second here. So that concludes the hearing for Senate Bill 373. We'll now move on to Senate Bill 374 with Senator Ellis.
Thank you again, Mr. Chairman, Vice Chair, members of the Judicial Proceedings Committee. For the record, Arthur Ellis, Senator from District 28, Charles County, here to ask for a favorable vote on Senate Bill 374, which authorizes golf carts to be ridden on Cobb Island. So yes, Charles County does have an island named Cobb between the Wycomico and Potomac Rivers. You have to cross a bridge to get there. You can also get there by boat, and we have approximately 1,000 residents on Cobb Island. It's kind of like a resort community. A lot of folks have their vacation home there, but a lot of full-time residents there also. And folks have a lot of golf carts that they ride around the contained island. There are no 4-lane highways through Cobb Island. It's basically slow, calm community. And right now, I must say they're riding their golf carts, and but they want official permission to do that, and so the county can regulate any violations of the laws as far as riding golf carts on Cobb Island is concerned. So the bill calls for a person who operates a golf cart on a highway on Cobb Island without registration may operate the golf cart only on a highway on which the maximum posted speed limit does not exceed 30 miles per hour. And believe me, that's all of Cobb Island between dawn and dusk. And if the golf cart is equipped with lighting devices, shall keep the golf cart as far to the right of the roadway as possible. And the riders of the golf cart should have a valid driver's license. And these are for low-speed golf carts. And I must say, this body has approved this legislation last session. We have quite a few new members here, so I've didn't want to bore you with all the details, but I felt it important for me to remind the new members out of respect what Cobb Island is and where it is and the flavor of the community. And as such, I ask for a favorable vote on Senate Bill 374. Thank you.
Excellent. Thank you, Senator. We did pass this bill last year, and you promised to take us to Captain John's Crab House. So we're
Yes.
still waiting for you to hold up your end of the bargain. I know, come on, you know.
We will do that.
All right.
Last year was an election year, so we're a little
You were a little
distracted.
busy. You ran unopposed though, so there's no excuse. All right. All right. Thank you very much, Senator.
You're welcome. Thank you.
All right, so next is Ms. Hilton and then Ms. Mitchell here. Are they there you are.
Hi, Senator. I think Ms. Hilton had some confusion about the in-person versus virtual, and so I don't believe she's going to be able to make it, if I'm not mistaken.
Okay, she's probably at Captain John's Crab House having lunch. Okay, all right. Thanks. Okay, you're up.
Okay, all right,
All
thank
right.
you. Well, again, for the record, Danielle Mitchell, Associate County Attorney for Charles County Government. I am here on behalf of the Charles County Commissioners in support of Senate Bill 374, motor vehicle registration, golf carts, and low-speed vehicles. Senator Ellis has already explained what the bill is. I would only add that this request originated from the residents of Cobb Island. They have a very active Cobb Island Citizens Association. I think over 100 signatures on a petition to request the legislation came before our Board of Commissioners, who do support it wholeheartedly. This appears to be similar legislation to previously enacted laws allowing for golf carts within Allegheny, Somerset, St. Mary's, and Dorchester counties within various communities in those counties. Allowing golf carts and low-speed vehicles would allow Cobb Island to match its peers of similar vehicle traffic levels and patterns. And our board has requested the feedback of our sheriff's office and our emergency services, neither of whom had any objections to moving forward with legalizing golf carts on Cobb Island. So with that information, we would appreciate a favorable report. Thank you.
All right, thank you very much, Ms. Mitchell. Seeing no questions from the committee, thank you very much, Senator. And with that, that'll conclude the hearing for Senate Bill 374. We'll now move to Senator Carrozza with Senate Bill 252. Senator Carrozza, welcome.
Thank you, Mr. Chair and members of the distinguished Senate Judicial Proceedings Committee. For the record, Senator Mary Beth Carrozza, I represent Worcester, Wycomico, and Somerset counties. And I want to thank the chair and the vice chair and all the members for this opportunity to present Senate Bill 252. Reckless and negligent driving, death of another, must appear violation, also known as Sherry and Christian's Law. And I'm respectfully going to ask for your support of this bill, which would require that a person charged with reckless or negligent driving, which contributed to the death of another, must appear in court. Now, Mr. Chair and members, most of you have heard this bill before. Last year, this committee, with unanimous support, passed this bill. It was sponsored by your former colleague and our friend, Senator Bob Casserly. And it was also passed unanimously in the Senate. Unfortunately, it did not make final passage in the closing days of the session on the House side. And I want to take this time to publicly recognize and thank Abate of Maryland for their leadership and persistence in advocating for SB 252 over the years. And I also want to note the strong support of the State's Attorneys Association, which has endorsed this bill, but after the deadline. Under current law, if someone is charged with reckless or negligent driving, even when they are involved in a fatal accident, they do not have to appear in court. They are charged with a misdemeanor and subject to a maximum fine of $1,000. And they can pay this fine without ever appearing before a judge or facing the loved ones that are left behind. This bill is named after two different victims of two different devastating accidents. On July 5th, 2019, Sherry Zahn and her husband Thomas were out for a late afternoon drive in Conowingo, Maryland, when they were struck head-on by an oncoming vehicle. Both Sherry and Thomas suffered severe injuries, and unfortunately, Sherry later died of those injuries. Her husband, Thomas, has had to have his left arm and his left leg amputated. To this day, the person who has caused Sherry's death has not appeared in court, as it is simply not required. Travis Christian Butcher, the other person referenced in the bill title, was driving to work the day before Thanksgiving in 2016 when he was hit on Route 7 in Agden, Maryland. He had the right of way, but the driver did not yield to him. After 3 days in shock trauma, Christian passed away from his wounds. He was only 19 years old. And despite a long rap sheet, the driver never had to appear before a judge for her actions. On average, there are 514 fatal crashes in Maryland each year. Being able to face the person who caused such pain often plays a major role in the healing process, and requiring that person to show up in court provides a safe environment. I want to note that there is some discretion for a judge to waive the must appear in order if the two parties meeting would be considered dangerous, such as if there was any type of gang involvement or other pressures. These type of cases where there is a victim should not be treated the same as a victimless vehicle accident. And Mr. Chair and Vice Chair and members, the time is now for the victims and their families, and I urge you for a favorable report on Senate Bill 252, and I thank you for your kind attention.
We'd have your guests come up and we'll take questions from the panel. I know Senator Fulton has a question, but we can have the rest of the panel go and then we'll do questions afterwards.
Good afternoon, Mr. Chairman, members of the committee. I appreciate y'all giving me the opportunity to testify on behalf of this bill today. My name's Robert Spanberg Jr. I'm the chairman of the board of ABATE of Maryland. Organization's in its 49th year of operation. We're an all volunteer organization. Our stated purpose is to further the safety, enjoyment, and affordability of motorcycling for all the citizens of the state of Maryland. With that in mind as our stated purpose, this has been a very important issue to us, and we've, as the senator stated, we've been lobbying for the passage of this legislation for quite a long time. It was kind of interesting. I did a little more investigating as to what actually constitute a must appear violation this year that I haven't done before, and was surprised to find out the number of different violations that actually warrant mandated court appearance. One of them, which is speed and red light cameras and accumulation of unpaid fines. The registrar of the vehicle has to show up in court, even though, as we all know, the cameras cannot determine who was actually operating the vehicle. That just seemed, I don't know, kind of odd to me. I'm not used to reading notes, but this bill, if it passed, I feel would bring closure for the families of victims of accidents where someone has lost their life. And with that in mind, I respectfully request a favorable report and a favorable committee vote. Thank you for your time. If there's any questions, I'm ready to answer.
Excellent. Thank you very much. We have a question from Senator Fulton.
Thank you, Mr. Chair. Senator Carozza. So I just wanted to say right off the bat, thank you. I know if I would love to have been a part of this, but it's an important measure because there's 4 words under this transportation article that mean the most to what this is about. And that is, in a reckless occurrence, it's the willful and wanton disregard for persons and property. And under negligence, it is the careless and imprudent operation of a motor vehicle, which endangers persons and property. So they both have relevance here. And being that I've been a crash reconstructionist and have had the unfortunate task of reconstructing fatals, hundreds of fatals, this bill is quite important. And I want to see this go through. So I'm going to leave anything else I had to say, including my co-sponsorship, off of it so that it has a better chance. Isn't that so?
Thank you.
Hey, as a member of the committee, we got you on the floor. So if you're going to bend yourself on. Your name coming out of JPR means something. All right, there we go. Okay. Seeing no further questions, Senator Croza, thank you very much. And thank you, sir, for coming by.
Thank you
All right. With that, that'll conclude the hearing for Senate Bill 252. We'll now move on to Senator Mouts with Senate Bill 303. Come on up. Welcome.
Thank you, Chairman and distinguished members. It's great to be with you. Senate Bill 303 may be familiar. This bill would authorize the installation of a speed traffic camera in the town of Oxford. Just as you enter the town, the speed camera, it was the request was a result of a horrific accident that occurred on July 1st, 2019. It is a spot that's attracted a lot of attention. The town has held a series of meetings. They've requested this. The town manager should be on for virtual testimony to ask any specific questions. But it's funny because making this transition, it's great to be here as a member of the Senate because I've testified on the bill from the House. You know, it came over from House Transportation. And I saw the distinguished chairman of the House Transportation Committee at the beginning of this session. And he walked up to me and says, "Hey, Johnny, how do you like that speed camera in Oxford?" And I said, "Well, Chairman, it didn't quite make it all the way through." So we're back at it one more time. There's going to be one proposed change to this, and the language before you, it is very prescriptive on where the revenues can be utilized. It would go right back to that specific intersection. The amendment that will come back to the committee will be to allow the revenues to be used anywhere in the town of Oxford for traffic improvements. They've got a number of issues in that town, and the camera will probably generate a minimal amount of revenue. So with that, I'd ask for your favorable report, and I very much appreciate your attention and time. Thank you.
Excellent. Thank you very much. We'll take questions. We have one virtual witness, and then I'll go to Senator Muse and Senator Folden. So we have Ms. Lewis, who is joining us virtually, and she's coming into the Zoom room. And once she gets here, Ms. Lewis, welcome. You're up.
Thank you, Senator Smith and committee members. I'm Cheryl Lewis, the Oxford Town Manager, and I thank you for this opportunity to speak to you on behalf of the elected officials and citizens of Oxford, Maryland, and greatly appreciate the virtual option. A letter was submitted prior to today providing further details regarding our request for a speed monitoring system to assist us in enforcing safe speed limits in our small community. We are a completely walkable municipality with a permanent population of around 600 located at the end of 50-mile-per-hour state highway. And once the speed reduces to 25 miles per hour, it does not change and ends at the water. We are a destination at the end of the highway, not a pass-through community. The location of this request is near the Volunteer Fire Company and the Community Center, both which have pedestrian traffic year-round and even more so in the summer months when we are fully occupied, with residents and visitors frequenting these locations, and Kids Camp, which is several hundred children traveling to and from the Community Center by bike. Our small police department has 3 officers at full staff, making it difficult to continually monitor speeding at the entrance and also service the rest of the town when we are busy. Since the tragedy mentioned by Senator Mouts, we have been diligently coordinating with MDOT to incorporate traffic calming methods in an attempt to change behavior and curb speeding, while also requesting authorization for a speed monitoring system, this being our 4th year and our first time speaking with you. We understand the requirements of the current speed monitoring law and will follow all necessary processes within it. We do not anticipate a windfall due to our size, but we will utilize funds to first implement pedestrian safety in town, starting with 3 crosswalks in the busiest pedestrian areas of the road, which have been discussed with MDOT. The citizens and the officials of Oxford appreciate a favorable report for SB 303 with amendment, and we thank you, Senator Mounts, for getting us this far.
All right, Senator Muse and Senator Folden.
Thank you, Senator, for coming. This is a local bill, is that right? It's
I
not statewide, or is
forget,
it considered local?
I forgot to mention that. Yes, it is a local bill. We have a letter of support from the town of Oxford, and we also have a letter of support from Talbot County. It's located in the intersection is located in Talbot County.
That's what I wanted. Okay, thank you very much. Okay.
The guy from Montgomery County knows all about these cameras and speed cameras.
It's a cautionary tale, my friend.
Yeah, I know. Thank you, Mr. Chair. Senator, thanks for bringing the bill forward. You know that I'm generally not in support of like speed type cameras and those type of things. However, having said that, I do support the use of red light cameras because those seem to be used as a general safety factor so that the general motoring public is not running the red lights. They know that there's a consequence. My question to you is, in the language in the bill, it says not more than one speed monitoring system. So is this a red light bill or is this a speed? Oh, it is a speed bill.
Yeah.
So is there a red light camera there?
No, so this is a stretch of road that has been a problem for years. It's been so problematic that they positioned a town officer to pull people over. We've expanded the speed limit another quarter of a mile outside of town. We've worked with State Highway now for about 5 years to do all sorts of traffic calming improvements, and there are many more. Part of the revenues would go to more traffic calming in the town of Oxford. The town of Oxford has seen a huge uptick in tourism, which it embraces and the county embraces, but at the same time, they've sort of been a little bit stifled in how to get motorists to slow down to prevent this, because the scenario is it's a straight road for about 2 miles amongst cornfields and woods, and it's a nice big open road. And then all of a sudden you find yourself in the town of Oxford, and it's the best of traffic minds have been invested in trying to do things, including putting 3D painting 3D objects on the road to confuse drivers, to give them the vision to slow down. And this is sort of the last ditch option. And I think the general consensus in the town is disfavorable towards the speed cameras.
Right.
However, because of the repeated problems and the significance of this last tragedy, where the fire company was waiting for this president of the auxiliary to cross the street, and her family was visiting from out of town, and they were on the porch watching her walk across the street while she was struck. And then the perpetrators then tried to flee as the firefighters responded. Everything that could have gone wrong that day went wrong that day, and
and that's a terrible story. I mean, that's just awful. And I understand a grieving community wants to have a response and a resolution. I guess my question is, in the traffic calming measures that were implemented, did they try, a lot of times the average road width for certain, road widths are painted at a certain width, depending on the mile per hour of the designated area. So as a calming measure, if you narrow the road width by paint, it makes the mind think that it's a lot narrower and they'll slow down. The other thing that they do in conjunction with that is the elevated, not the paint, but the elevated speed humps going into town, 2 on each side. Is that something that was already put in place?
I'll let the town manager, Mrs. Lewis, respond to that and what's planned to go and what has gone already. Is that okay?
Yes, sir.
Okay.
Thank you.
Thank you. First of all, we don't have a red light, so I just wanted to make sure you understood that we would certainly look at that if it were an option. The only thing we have is a flashing light for a fire call. We have been working with the state. They recently repaved, and they've added tick marks as you enter town that is meant to basically kind of tell somebody they've changed, that it's changing, something's changing, and to notify them. One of the things we've asked it to look into is possibly trees to also narrow it. We installed our own speed awareness sign several years ago, actually in 2020 with citizen donations that tells people the speed as they're entering the town once they've gone through the 35-mile-an-hour. And we've also worked with them with trying to narrow some of the roads once they're within town. But we are able to look at the speeds, and we see that there may be some change, but there just isn't the change you'd like to see. People are generally traveling through that quarter mile of 35 mph at least 50. It's not unusual to get 20, 30, 40 notices a day on my phone that people have gone through there at 50 miles an hour. People know we're small. They know that there's not enough presence. They know that they can usually get away with it. And that's the concern is, you know, the person that's not expecting it has no idea that they could step into the road and somebody would come in there at that speed. We've tried a lot of things. We know this isn't the end all answer, but in our small community where we have 1 mile of highway going through it, and then we're at the water, this was one way to kind of get drivers to understand that we really want them to do 25 when they get here.
Thank you. So this is like Chrisfield, that where it kind of ends into the end of town at the water. Is that correct? Is that why you would only need one camera going in one way?
Correct.
Okay. All right. I appreciate your time. Thank you.
Thank you.
All right, seeing no further questions, thank you, Ms. Lewis, and thank you, Senator.
Thank you.
All right, with that,
Thank
that'll
you very
conclude the
much.
hearing for Senate Bill 303. We'll now go to Senate Bill 427 with Senator Quarterman. Welcome. And Ms. Hilliard, you can come on up as well.
Stand, sit, how do you guys, doesn't matter? All right. Chairman Smith, Vice Chair Wallstreicher, members of the Judicial Proceedings Committee. For the record, Senator Paul Quarterman, District 2, representing Washington and Frederick counties. Thank you for the opportunity to present Senate Bill 427 to you this afternoon. As we continue to rehabilitate individuals and prepare them for reentry, it is critical that we are setting them up to succeed to maximize their chances of success. The intent of this bill is to assist those individuals in the reentry process by facilitating their release from our state correctional facilities to their local jurisdictions. This will help connect them with local reentry services, parole and probation, job placement, other wraparound services to ensure their success. The bill would require that after an inmate is released from confinement in a state correctional facility, that the Division of Corrections would transport that individual from the correctional facility to the jurisdiction where the inmate was domiciled immediately prior to the inmate's confinement. To determine that location, the State Department of Corrections will use the address that is recorded by the correctional facility in the offender case management system at the time the inmate has entered the correctional facility. Furthermore, it's asking that the Division of Parole and Probation will supervise any required probation, parole, and mandatory supervision of that inmate in that jurisdiction as well. There are 3 state correctional facilities located in Washington County. Within a 4-year period, there were over 1,700 inmates that were released into Washington County from those 3 facilities, of which a little over 1,200 of them were individuals whose crimes originated outside of that county. This translates into roughly 70% of the individuals released into Washington County, again, with those from people that were outside of the community. Additionally, it should be noted that it should come no surprise that parole and probation, their caseload in jurisdictions that house the majority of these incarcerated individuals has historically been some of the highest caseloads in our state. Without the proper support system in place, there's a disservice that is being done to both the individuals being released from our state facilities and also to the local communities where these facilities are located. These communities surrounding most of the correctional facilities simply cannot keep up with or handle this population influx, as they simply don't have the proper resources, the proper support systems in place to assist these individuals through success. If we're not providing these services and the support systems as they reenter our society, there's a far greater likelihood that they won't be successful. And when this occurs, we've all failed. We failed not only the communities, but more importantly, we have failed the individuals that we're trying to reintegrate back into society. You'll see a letter of support from some of our local nonprofit community, including one of the leading reentry programs in our county, Gatekeepers. Their work takes them inside of these state facilities, and they see and they recognize the exact challenges we're speaking of here today as they try to find services and support systems that quite frankly just aren't there in our local community. It's not just an issue here in Washington County. We have a letter of support from our mayor and city council of Hagerstown, as well as our board of county commissioners in Washington County. You'll also find letters of support from the Allegheny County commissioners, as well as the Somerset County commissioners. 6 of the largest correctional facilities in our state are located in just these 3 counties. That's approximately 60% of all the incarcerated individuals, again, in just those 3 counties. And upon release, these localities simply don't have the ability to provide the successful resources that we are all striving for. Thank you for the opportunity. I appreciate the consideration and respectfully ask for a favorable report on Senate Bill 427. Thank you.
Excellent. Thank you very much, Senator. And Ms. Hilliard is in opposition, so we'll take questions now before we switch to the opposition panel. Seeing no questions from the committee, thank you very much, Senator. Ms. Hilliard, you're up.
Good afternoon, Chair, Vice Chair, members of the committee, Elizabeth Hilliard, Maryland Office of the Public Defender. I agree with a lot of what the senator just said, and our office agrees with that. We certainly encourage efforts to transport people to reentry services, to transport them to where they will be most successful. However, this bill does not do that. It transports someone back to the place that they were domiciled before their entry into a facility. There is no accounting for a release plan that may have been worked out with a social worker, either outside of DOC or within DPSCS. There is no accounting for someone wanting to move from the area that they were living in that led them into the facility that they are being incarcerated. There is no accounting for bus fare, other transportation, resources and services. And there are no guardrails in place to ensure that the person is being returned, to a place that will serve them and will ensure that they are safe when they reenter the community and that the community is safe upon reentry. So I guess I could say I'm favorable with heavy amendments or oppose at this point. But we would ask that if you are inclined to pass this and you do want to vote favorably on this bill, you consider all of these circumstances that need to be accounted for in such a service and in such a transportation effort. Thank you.
Thank you. And thank you, Senator, for sharing that. And thank you for your response. I want to see how, I want to envision how this would happen. An inmate is released. Upon their release, you ask them where do they want to go, or they tell you where they want to go. And then you provide the transportation. Is that how it goes? Or how this bill is set up?
So again, maybe there are a few amendments per se that we need to work out to a certain point, but to answer your question, we're kind of speaking the same thing. The intent of this is not that someone just comes out and they're on their own.
Right.
We fully support developing a home plan. I think is what she's getting at, is to having a home plan so there's a stable environment that the inmate's being released to. We also feel strongly that unfortunate reality is a lot of the smaller communities where the correctional facilities are located, they don't have those support systems in place.
Okay.
If we do have them, we have not only reached our threshold, we far exceeded our threshold to be able to provide that support and the ability to provide the success. So again, we're in agreement that a home plan needs to be developed, transportation needs to be given. Pre-release starts happening usually about a year before someone is released.
Right.
And so we would like to see is that path is being, tailored towards the jurisdiction that they entered from to begin.
So under this bill as written, and to envision what would happen, again, an inmate says, I want to go to Baltimore, and you would make arrangements or pay.
Yeah, the
or
Department
they
of
would pay,
Corrections.
however it's done.
Sure.
They will be is that, and if that's not explicit in the bill, would amendments?
Yeah, I mean,
that
the
would,
actual physical transport itself, Department of Corrections ends up transporting the individuals to wherever the home plan is already, that's what happens now. Like a home plan is defined and determined upon release.
Okay.
And Corrections takes into that home plan. So that's what we're getting right down into the weeds of the home plan of where that is.
But that seems to
set
be
up.
the objection. And that's why I want to talk to, again, refer back to the Public Defender's Office. So is that how you envision this? Oh, and if that is the case, what is your objection to the bill?
The way it's written now, that is not what is accounted for. The way it's written now, it very specifically says that the person will be sent back to their last known address, essentially, which is not accounting for any of that. I mean, some of the people, especially in Cumberland, are serving 15, 20, 30-year
don't have
sentences.
anything.
They don't have, yeah. And so if the bill was specifically reworked to account for a reentry plan, absolutely, we could definitely talk about being favorable. And I will note, actually, there is a bill in front of you all that is a work group to study reentry plans. And if we wanted to accommodate this with that and combine those, I think we would be in favor of that. But this, the way it's written right now, just has absolutely no safety mechanisms in place, no guardrails to prevent someone who's been, incarcerated for 30 years being dumped back to a place that they don't belong.
I like the bill. I want to see the bill work. So if you all can get together and with the bill that you're talking about, Mr. Chairman, if you can, however you all want to proceed and go forward, in the West.
Yeah, I
Okay,
believe it
if
is.
you all get together,
I
let's
didn't mean to put
figure
you on
out
the
a
spot,
way
Senator West. I apologize.
to work this out so
Create
that,
more work for you.
so that everybody's good with this, because the idea is good. I understand your concern there. And I think it's a doable way of making this work and move forward for those counties down there who bear a lot of the burden. A lot of,
Yeah, we want to
they didn't
see people not
They didn't
return
ask
to the system. So we're happy to try to work them to the best resources they can get.
Okay, thank you. Anything I can do, let me know. Any information you can share.
Thank you
with
very
me,
much,
let me know.
Senator. Thank you.
Thank you very much. Okay, thank you, Senator.
All right, seeing no further questions from the committee, thank you very much, Senator. Thank you, Ms. Hilliard. All right, so with that, that'll conclude the hearing for Senate Bill 427. We'll now move on to, Senator Hester is here. Senator Hester will move on to Senator Hester's bill 254. Senator Hester, welcome.
Thank you, Mr. Chair. For the record, Senator Katie Fry Hester, thank you for your consideration of Senate Bill 254. I'm here to talk about a problem that we have affecting our smaller charities and our nonprofit organizations that has to do with the state requirement for an audit. Specifically, the state requires a charity that exceeds $750,000 in revenue to provide a financial review or an audit, which is perfectly reasonable if the revenue was defined as all cash. However, the definition of revenue includes donated property, and there are many nonprofits that have upwards of 80% of their quote unquote revenue in donated goods as opposed to cash. Because an audit can cost up to $20,000, our smaller nonprofits cannot necessarily cover their cost with their operating cash flows. This rule then unintentionally disincentivizes these small charities performing significant services for underinvested communities to grow. Just to give you a couple of examples, and you'll hear from a couple of charities today, when an organization gets free bikes or free wheelchairs or free food, and the value of that exceeds the $750,000, that then prompts the need for this audit, which is really expensive. So this looks like a simple bill, but it was actually very complicated to draft so that it narrowly applies to this exception while making sure that our Department of State can properly regulate these charities. So currently we're working with the Department of State. They support the bill's intent, but they're helping us to draft an amendment, which my office has requested, which should address our concerns. Michael Schleen, from the Division Manager for Charities, is here today from the State Department's office to answer any questions you might have. But for these reasons, to help these small profits who are doing really good work in your organizations, I ask for a favorable report on Senate Bill 254. Mr. Chair, I do have a small panel with me.
Well, thank you. You want to bring him up? Come on up.
Hi, I'm Ted Cochran. Good afternoon, Chair Smith, Chair Waldstreicher, and committee members. I'm the president of Free Bikes for Kids Maryland, and we're a nonprofit that helps thousands of Maryland children in need ride into a healthier childhood by giving them free bicycles. The public donates used bikes, our volunteers refurbish them, and we give them away with new helmets to underserved Maryland children, about 6,200 in the past 3.5 years. The need is great. We're growing as fast as we can, and we're in favor of this bill as amended. There are several Maryland nonprofits that collect and freely distribute goods such as medical equipment for disabled children, food, books, toys, and sporting equipment. We all have significant non-cash donations in the form of property, and we all follow generally accepted accounting principles, or GAAP, to improve the communication of financial information to our stakeholders. So here's the issue. GAAP was revised in 2021 to require that the value of non-cash donations, in our case bicycles, be determined and added to our revenue. So this year, our gross revenue may be about $390,000, of which $335,000, or 86%, will be from non-cash donations of bicycles. Thus, under Maryland law, we'll be required to conduct a financial review that will cost as much as $10,000, even though our budget from cash donations will only be about $55,000. Because of the updates of GAAP, the current law is a disincentive for nonprofits to adopt GAAP and a burden on our nonprofits. So Senate Bill 254 as amended changes the definition of some non-cash donations to be consistent with IRS rules and current practice, and also excludes property redistributed without charge to Marylanders from the revenue that determines audit thresholds, while requiring that the property redistribution be the primary purpose of the nonprofit and imposing a number of worthwhile safeguards, which we support. We hope the amendment language will not limit the contributions too much. Nonprofits that redistribute property require funds to cover the cost of refurbishing and distributing non-donated property, and we have other costs such as our purchase of new helmets. So we respectfully request that the limit be 20%, and passing the bill as amended will help nonprofits like ours continue to efficiently provide valuable services to Maryland residents. We urge you to give the bill a favorable report. Thanks, Senator Hester, for sponsoring the bill, and I thank you for your time.
All right, thank you, sir. Thanks, Senator. And the gentleman from the Secretary of State's office, are you going to provide testimony, or are you here?
Just here for technical questions.
Oh, here's a technical question for you. So the word eleemosynary,
The very fancy word that means
to say charitable. Yeah.
You know, you can't define charity with the word charity, so they throw an eleemosynary.
Okay. All right.
That's the best I can
There you
do.
go. I was like, I had to look that up. So, yeah.
I didn't know how to pronounce that until I started working here.
Okay. So that's the word of the day. All right.
Yes.
All right. Well, it's a technical question, so
Yeah.
glad you can answer it for us. All right. Seeing we have a question, Senator Sidnor.
Good afternoon. The question that oh Lord, have mercy. Oh, I know. Maryland nonprofits, they said favorable with amendments. I'm curious, where are we with your amendments, and what would the amendment do?
So the bill as originally proposed was changing the definition of what a non-cash contribution was or is. And Secretary of State's office and the legislatures are trying to figure out a better way to have the same effect without changing the definition of a charitable contribution, because we still want to have solicitations for bicycles, for example, to be subject to the rules. We just don't want to have the bicycles be subject to gross revenue requirements for audits.
So, but I mean, this could be a house, it could be a car, anything beyond just bikes, right?
Yes.
And I think to their point, I mean, you could be talking about substantial contributions that, I mean, non-cash, but still substantial contributions that would have to be captured on an entity's 990s.
Yes, so non-cash contributions are reported on 990s and will continue to be. The donations of that non-cash property to Maryland residents is also reported on the 990. So the bill would only apply to property that's donated to us and then turned around and given free of charge to Maryland residents. So if somebody were to donate a house to a nonprofit that gave away houses to Maryland residents, then this would apply. But if they are donating a house that is sold for the benefit of the nonprofit is doing other things, it would not apply.
Mr. Schlein, if I could ask you a question.
All right.
Is it possible that an organization would not have to register to solicit charitable contributions if the only types of charitable contributions they received were bikes that they intended to provide without charge to others?
Not with the amendments, the way it was originally drafted, that was, and I think an unintended consequence of that. Which is where our concern was. We didn't want gifts in kind removed from what is a charitable contribution that would be subject to registration and reporting requirements. So the amendments to the bill would undo that error or unforeseen act, and an organization that solicits in-kind contributions only would still be subject to the registration requirements of the Maryland Solicitations Act with the amendments.
Thank you.
You're welcome. All right, seeing no further questions, that'll conclude the testimony for the proponents of the bill. You do have one witness signed up in opposition. Ms. Bogley, you're testifying virtually. You're up. Welcome.
Thank you, Chairman Smith and members of the committee. I'm Laura Bogley, Executive Director for Maryland Right to Life. On behalf of our members across the state, we oppose this bill as written because we're concerned that by excluding property and in-kind donations from the definition of charitable contributions, taxpayers will be prevented or may be prevented from seeking tax relief and credits for the value of these contributions. The state should be careful that the bill cannot be used to infringe on our First Amendment right to freedom of speech and association and empower political partisans to engage in content discrimination to the detriment of an organization with opposing viewpoints. In recent years, we have witnessed a dramatic increase in political violence and government persecution of pro-life citizens and pregnancy centers. We have seen political partisans use the full weight of federal institutions like the IRS to deny rights and equal opportunity to faith-based organizations. The United States Supreme Court, in their 2007 decision, Federal Election Commission versus Wisconsin Right to Life, held that it was unconstitutional for the FEC to ban advertisements by Wisconsin Right to Life, a nonprofit advocacy organization promoting pro-life issues. In 2010, the court's ruling in Citizens United and versus FCC affirmed that spending is speech and is therefore protected by the Constitution, even if the speaker is a corporation. So the court rejected the idea that government can decide who gets to speak, particularly those who speak through associations of members who share their beliefs. Finally, the court held that independent advertisements and expenditures, including those made by corporations, do not give rise to corruption or the appearance of corruption. Speech is an essential means of democracy and the means to hold officials accountable to the people. As such, free speech must prevail against laws that would suppress it. We believe these concerns may be alleviated by existing amendments that we haven't seen or new amendments, and we ask you to consider that. Thank you.
All right, thank you very much, Ms. Bogley. We actually have one question from Senator Sidnor.
And good afternoon. I'm curious because simply removing property out of a state definition of what a charitable contribution is shouldn't affect whether or not there's a federal tax deduction, because it still would be considered a contribution under federal law, correct?
Is that question addressed to me, Senator Sidnor? I'm sorry, I'm not in the room.
Yes, ma'am.
Okay, fine, thank
And
you.
then, and if you're unable to answer, I'll
Right,
say.
we're concerned with any type of state modification, subtraction modification, any future credits that may be available or listed under future legislation under state tax relief. With the subtraction modifications, I know there's been a lot of decoupling by the state of Maryland where they don't recognize some adjustments to income and credits that the IRS recognizes. And so that would be the concern going forward.
All right, but this particular modification is to, I think, the business regulations, right? Yes, to the business regulations, not to the tax section of our code. So what it affects, and you can again correct me if I'm wrong, but what this would affect is whether or not this organization would have to deal with certain the regulations that the Secretary of State enforces with regulation of soliciting contributions, not whether or not something's considered deductible, and whether someone could get a income tax deduction on it. I mean, that's my read. Am I correct?
Yes.
Thank you.
Not tax code, just reporting required.
reporting requirements of the Maryland Solicitations Act. It doesn't impact tax code or deducting taxes or anything like that. Yeah.
All right, thank you, Senator Sidnor, and no, that's good. Yeah. Yeah, I'm serious, that was good. All right, seeing no further questions from the committee, thank you, Senator Hester, and thank you all very much. Thank you. All right, so with that, that'll conclude the testimony and the hearing for Senate Bill 254. We'll now go on to, well, we'll go to Senator Sidnor with Senate Bill 293. Senator Sidnor.
All right, for the record, Senator Charles Sidnor for Senate Bill 293. Something that I believe is a very simple bill, but very important. The other night when we were sitting in executive nominations, when we had a chance to listen to our new nominee for Secretary for the Department of Public Safety and Correctional Services, when she was talking about folk who are incarcerated, rather than using this outdated term of inmate, she referred to them as incarcerated individuals. This bill that I put forth may look like it's just a semantics change, but it's a bit more than that. So again, it changes state law to make that modification from using the term inmate to incarcerated individual. I will be honest, I had not thought about this up until maybe I think it was back in December. I happened to have a conversation with our former Secretary Green, and he had made mention of what he believed would be the benefits of a bill like this for people's psyche. For the most part, you have individuals who are, I would say the majority of them, they're not going to be incarcerated for the rest of their lives. They're going to come out, they're going to be back in society, hopefully re-entered properly. This particular legislation is based on something that was modeled on a New York state law that passed last year. And really, that's what the bill does. It makes the modification from using the term inmate to incarcerated individual. That's it.
Excellent. Questions from the committee?
Very non-controversial.
Yeah, I'm seeing that now. I applaud the efforts. All
Thank
right. Seeing no questions from the committee, that'll end the testimony in the hearing for Senate Bill 293. Our last bill of the day is Senate Bill 446, Senator West. Senator West is currently in another committee testifying on another bill, so we will await his arrival. And then when he does get here, he has 4 witnesses, so it should be a relatively short hearing. So we're going to continue the stream. We're not going to break. We're just going to wait for him to come back. So you'll just for the people watching at home, you'll just see a stream of the back of the wall for a little bit.
We move to the other side. It's not. Yeah, no, it's perfect. I'm not on it. I was like, well, but I said I know that.
Sorry. All right, here we are. Senator West with Senate Bill 446. You're up.
Thank you, Mr. Chair. This is Senate Bill 446. Chris West, it's a pleasure to be here to present this. This bill was brought to us by the Estates and Trust section of the State Bar Association. We're talking about now trusts set up by people during their lifetimes before they die. So when a trust is established and circumstances later change, the trust terms sometimes frustrate the purposes of the trust. An example of this is a trust that will soon distribute its funds outright to a trust beneficiary when he turns 30. But if the settlor had known that the beneficiary would be suffering from addiction or bankrupt or undergoing a divorce or qualifying for governmental assistance, the settlor probably never would have required the outright distribution at that age. So what sometimes trustees do is they decant the trust assets in this kind of a situation. So much like you take wine from a wine bottle and you pour it into another bottle and you let it sit for a little while before you actually pour it into the wine glasses, the trustee would like to decant the trust assets into a new trust. The new trust devised in a way which would benefit the beneficiary in the way the settlor would have wanted if the settlor only knew what circumstances the beneficiary was going to be in at the time that the assets from the trust are supposed to be distributed to the beneficiary. Now, a lot of states have decanting provisions. Maryland doesn't at the moment. And so what this means is some trustees try to move their trusts to other states so they can take advantage of the decanting provisions in the other states and thereby benefit the trust beneficiary in a way which the settlor would have done if the settlor only knew at the time he created the trust that the beneficiary was going to be in difficult circumstances at the time the assets under the trust are supposed to be made available to the beneficiary. So in Maryland, court proceedings are sometimes initiated to move the trust to a jurisdiction that allows decanting, or alternatively, to argue that Maryland's common law allows distributions of assets into a further trust. So decanting allows the trustee to set up a new trust for a beneficiary, and this bill, Senate Bill 446, provides carefully outlined restrictions on whether and how decanting can be done. So the threshold question under Bill 446 for the trustee is whether doing so would further the purposes of the original trust. A trustee is not permitted under this bill to add beneficiaries or to take away a vested interest, or to include provisions that would personally benefit the trustee. There are several provisions clarifying what a trustee can do and cannot do regarding decanting. And prior to exercising the decanting power, the trustee would have to provide 60 days notice of the trustee's intent to exercise the power of decanting to various individuals involved with the trust, including the settlor if the settlor is still alive, the other qualified beneficiaries, and all other fiduciaries. This is a complicated bill and it's rather lengthy. It's a comprehensive means of ensuring that trusts are set up to benefit a beneficiary, continue to benefit the beneficiary despite a change in circumstances after the trust was established by the settlor. So I appreciate the committee's consideration of this bill. There are two witnesses here today from the Estates and Trust section of the State Bar Association who can describe this bill in more detail and answer your questions.
Thank you, Senator. Thank you for the bill. Just before we get into the witness testimony, it would be extremely helpful if we could do kind of like a crosswalk and line by line reference with the bill, and maybe like a vignette or two of how this actually works. Like seriously, I'm serious. Like just like a couple of examples, because I'm great on the idea. Very unsure as to the implications of like this. It's a very long bill, and so as we go through it, Senator, some of us are actually going to read this entire bill a couple of times, and it'd be good to have a couple of examples of how this works. And they're probably innumerable examples of how this is going to be implemented in the future. But it would be helpful if we could have something like that.
Fully appreciate that. And when I first took a look at the bill, it was long and somewhat confusing. And so I got that sort of an explanation from Sarah Call, who is here. She actually wrote the bill. So with respect, if I could defer to her to go through the bill and tell you page by page what's going on.
No, I mean, we're not doing that exercise right now. I mean, we'll do that. We'll do that later on, but
and much as in the case with Bill Carlson, Ms. Call is available at any time to consult with the committee, even come down here and meet with the committee to go over the bill.
And we could even do it Zoom. I mean, we're basically just gonna put it up on a screen. A couple of us are gonna go and read the entire thing. So, okay, thanks.
Yes, thank you, Senator West. Thank you, Mr. Chair, members of the committee. My name is Sarah Call. I am the chair-elect of the Estate and Trust section of the Maryland State Bar Association, here in support of Senate Bill 446, which is based on the Uniform Act. So I believe that we have a member of the Uniform Law Commission here as well. So this is very consistent with the Uniform Act on decanting. Much of Maryland trust law is about, of course, following settler intent. But then when there are situations where the settler's intent is frustrated by the terms of the trust, then there are a few options for Maryland trustees. As Senator West described, a lot of times the best option is decanting, where the trustee actually moves the trust from Maryland to one of the more than 30 other jurisdictions that have a decanting statute. And in worst cases, some trustees are arguing that the common law in Maryland does allow decanting already. So they're moving forward with a decanting without the protections that would be available in a statute like the Uniform Act. And those protections are important. The Estates and Trust section represents settlers, trustees, and beneficiaries, so their interests are all important to us. The protections that Senator West identified are the limitations that are there for trustees, things that trustees can and cannot do. So when we meet with members of the committee, we're happy to go through line by line where the guardrails are, what a trustee can do and cannot do. Like any decision that a trustee makes, if the trustee acts improperly in decanting, then there's an ability for the beneficiaries to challenge it. Trustees can be held accountable if they misuse this power, like any other power that a trustee has. We believe that Senate Bill 446 offers trustees an important tool that Maryland has been lacking to further the purposes of trust when circumstances change. And for that reason, we ask a favorable report. Thank you.
Thank you, Mr. Chair and members of the committee. My name is Christia Pritz. I'm the Secretary of the Estate and Trust Section Council for the Maryland State Bar Association. I'm here to testify in support of Senate Bill 446. As has been previously mentioned, more and more as attorneys, we have clients coming to us with trusts that have problems with them because the way they were drafted at the time, it wasn't anticipated that circumstances could change with regard to the beneficiaries. And as we work with our clients to try to fix this, we just do not have very good tools currently in Maryland for doing that in a situation where we really need a brand new trust with the right kind of terms to protect the beneficiaries. As Sarah mentioned, the common law isn't completely clear in Maryland like it is in some other states. We don't have anything statutory. We do have some other tools such as a non-judicial settlement agreement where the trustee and beneficiaries can enter into an agreement to modify a trust, but that doesn't work very well in some of these situations where decanting would be better, because with a non-judicial settlement agreement, you need the beneficiary to agree to do it. If the beneficiary is someone who's going through a horrible marital situation, we don't want them to do anything that could open up the assets in a divorce claim because they've entered an agreement to put it in a trust for their own benefit. Also, judicial proceedings aren't ideal where we would have the client petition a court to modify the trust because it's a public proceeding. And a lot of the times the issues that we're trying to help the clients with when we're looking to decant are very private issues that they would prefer not to be made known to everyone. So it would be very helpful for us as practitioners if we could have this tool to help our clients, as was mentioned, to further the settler's intent and to also protect beneficiaries who are in very difficult circumstances. So I urge you to give a favorable report for Senate Bill 446. Thank you.
Excellent. Thank you very much. And then we have one witness testifying virtually. Benjamin Orzecki, you're up. Welcome.
Thank you, Mr. Chairman. Appreciate the opportunity to participate in the hearing by Zoom. I'm Ben Orzecki. I'm Legislative Counsel at the Uniform Law Commission for Uniform Trust and Estate Acts. And I won't repeat the excellent description that was given by members of the Maryland Bar. I will mention that this is a relatively new Uniform Act. It was approved by the Commission 7 years ago. For exactly the reasons that were stated. The common law here is pretty scant. There were some cases that were indicating that the decanting tactic could be abused, maybe used to defeat the trust, the settler's original purpose rather than to further it. So this Uniform Act was intended to kind of put parameters around the decanting process, put some guidelines in place that would be useful for both trustees who want to exercise it and for attorneys who are drafting trusts so that they can anticipate what might be needed in the future or what might be allowed in the future under the decanting rules. It's been adopted so far in 13 states, including a few neighbors of Maryland. It's been adopted in Virginia and West Virginia, and I know it's under study in the DC Bar. In addition to Maryland, it's been introduced this year in 2 other states, in Kansas and Massachusetts. So I think that as state bar associations are considering this issue and trying to update their law, this is becoming a useful model and becoming widely adopted. And of course, as with any uniform law, the more widely adopted, the more uniform the law will be, and we can kind of settle on what it should be. It was drafted, as all uniform laws are, by a committee of experts open to any interested participant who wanted to join the meetings and offer input. And we offer it today for your consideration. Thanks very much.
Excellent. Thanks. We have one question from Senator Sidnor.
Thank you. And until today, I haven't heard of this process, but what I'm curious, you have a trust that may have been made back in, let's say, 1870, and that trust was put in place to ensure the financing of a whites-only facility. Obviously, public policy dictates we don't want to do that today. Would this process that you're putting together help a trustee that might be managing those types of funds to ensure that I guess it could decant that first trust and create a second trust in order to meet some other needs? So how would this work with that type of a hypothetical?
The answer is potentially yes, it could help in that situation. Of course, the terms of that trust would probably be unenforceable anyway, but the trustee might be kind of hamstrung as to what they do with the funds if they can't administer the trust in accordance with its terms. If the beneficiary is a charitable organization of some sort, then under the Uniform Act, the Attorney General has to get involved to make sure that the charity's interests are protected. But yes, this could be used to decant funds from a trust that has become impossible to administer in that manner into one that is easier to administer and hopefully can still benefit the type of charities that the settler originally intended, even if not under those sorts of restrictions.
Thank you very much.
For anybody that wants to answer this, and I appreciate and agree that I would need to read this bill 3 or 4 times. So what I'm asking might be something we'll answer later, but I just want to know thematically, and maybe you could point me in the bill, what are the provisions to discern the settler's initial intention? You, Senator West, indicated there could be change of circumstance, divorce, addiction, somebody could become reckless with money, somebody could become disabled, which is extraordinary, but I think you can already handle that sometimes. But where would we find in this statute, because that's the first thing I want to kind of look at, is the language that helps guide us on the settler's intent that would justify, decanting to a second trust.
Thank you, Senator.
It may be sprinkled throughout, so you might not be able to answer it.
Well, I would point you to section 14603, which does say that in exercise, I'm sorry, page, let's see, page 5, line 20.
Okay.
So in exercising the decanting power, unauthorized fiduciary, that's generally the trustee who's going to be decanting, shall act in accordance with its fiduciary duties, including to the duty to act in accordance with the purposes of the first trust. So there's a general fiduciary duty of the trustee to act in accordance with the purposes. And so this is highlighting that initial purpose. Now, you'd have to look at the trust agreement itself to figure out what those purposes are. But that's where the fiduciary duty
does
comes
it work
in.
like this? So you would first discern the purposes of the first trust. And then this is just very general. Because there might be a change in circumstance, realize that the change in circumstance could somehow thwart the first trust. Is that sort of the process we're going through? And once you can establish that through review, right, then allow a second trust to be more consistent with the changing circumstances because they weren't written out in the first trust because they didn't exist. And is that sort of thematically how it works?
Right, that it would be sort of the second trust would make changes to the first trust within the parameters of the statute that would, that would further the initial purposes, whether it's, generally going to be to benefit a particular beneficiary.
Right.
So it's usually going to be fairly broad in that way, right? The purpose is to help this particular person with their needs, and usually it's fairly clear that a distribution would not further their needs.
So echoing what the chairman said, but maybe being even more specific, I would really like a walkthrough in writing, and then we can talk of how this would work, giving several examples like it, these changes, divorce, if that's what you want to use this for, somebody who's become, mentally sick. I don't know if you would use it for that, drug addiction. So I'd like to see how it applies to some real world.
Yes, happy to do that. Thank you, Senator. And just to be clear, we don't specify in here any particular reasons or purposes because of the myriad situations that can come up. But yes, we'll show you the examples.
No, but the vignettes will be helpful just to understand how it works in practice. I mean, I know that like I said, there are innumerable examples of how this will be applied, but it would be helpful for us that don't do this work to understand how it works. Because we're going to have to also explain to our colleagues. So, All right, any further questions from the committee? All right, seeing none, thank you all very much. Thank you, Senator West. And with that, that'll conclude our hearings for the day.